Freedom to form association. Articles 19(1)(c) and 19(4). Article 19(1)(c) of the Constitution of India guarantees to all its citizens the right to form associations and unions. Under Clause 4 of Article 19, however, the state may by law impose reasonable restrictions on this right in the interest of public order or morality or the sovereignty and integrity of India. The right of association presupposes organization. It has an organization or permanent relationship between its members in matters of common concern. It thus includes the right to form companies, societies, partnership, trade union, and political parties. The right guaranteed is not merely the right to form association but also to continue with the association as such. The freedom to form association implies also the freedom to form or not to form, to join or not to join, an association or union. In Damayanti vs. Union of India, AIR 1971, the validity of Hindi Sahitya Sammelan Act 1962 was challenged as violative of Article 19(1)(c). The petitioner was a member of an association. The Act changed the composition of the association and introduced new members. The result of this alteration was that the members who voluntarily formed the association were now compelled to act in the association with other members in whose admission they had no say. The Supreme Court held that the Act violated the rights of the original members of the society to form an association guaranteed under Article 19(1)(c). The right to form an association, the court said, necessarily implies that the person forming the association have also the right to continue to be associated with only those whom they voluntarily admit in the association. Any law by which members are introduced in the voluntary association without any option being given to the members to keep them out, or any law which takes away the membership of those who have voluntarily joined it, will be a law violating the right to form an association. The Hindi Sahitya Sammelan Act does not merely regulate the administration of the affairs of the original society. What it does is to alter the composition of the society itself. The result of this change in the composition is that the members who voluntarily formed the association are now compelled to act in the association with other members who have been imposed as members by the Act and in whose admission to membership they had no say. Such alteration in the composition of the association itself clearly interferes with the right to continue to function as members of the association which was voluntarily formed by the original founders. The Act, therefore, violates the right of the original members of the society to form an association guaranteed under Article 19(1)(c). As regards the plea that the Act imposes reasonable restriction under Clause 4 of Article 19, the Court said that Clause 4 cannot be called in to claim validity for the Act. Under Clause 4 of Article 19, reasonable restrictions can be imposed only in the interest of the sovereignty and integrity of India or the interests of public order or morality. The alteration of the constitution of the society in manner laid down by the Act is not in the interest of the sovereignty and integrity of India or in the interests of public order or morality. Right of association and armed forces. In O.K. Nair vs. Union of India, AIR 1976, an important question arose whether civilian employees, designated as non-combatants such as cooks, chowkidars, laskars, barbers, mechanics, bootmakers, tailors, etc., attached to the defense establishments have a right to form associations or unions. The appellants were members of the civil employees unions in the various centers of the defense establishment. The Commandant declared their unions as unlawful associations. They challenged that the impugned action was violative of their fundamental right to form associations or unions under Article 19(1)(c) of the Constitution. They contended that the members of the unions, though attached to the defense establishments, were civilians and their service conditions were regulated by civil service rules, and therefore they could not be called members of the armed forces within the meaning of Article 33 of the Constitution. The Supreme Court rejected of the appellants and held that the civilian employees of the defense establishments answer the description of the members of the armed forces within the meaning of Article 33 and, therefore, were not entitled to form trade unions. It is their duty to follow or accompany the armed personnel on active service or in camp or on march. Although they are non-combatants and in some matters governed by the civil service rules, yet they are integral to armed forces. Consequently, under Army Act, the central government was competent to make rules restricting or curtailing their fundamental right under Article 19(1)(c). In Delhi Police Non-Gazetted Karmachari Sangh vs. Union of India, 1987, the validity of a statutory rule which empowered the government to revoke the recognition granted to the appellants Delhi Police Non-Gazetted Karmachari Sangh to form association was challenged on the ground that it was violative of Article 19(1)(c) of the Constitution. It was argued that recognition once granted to the Sangh could not subsequently be revoked. Recognition carried with it the right to continue the association as such. To derecognize the association offends against the freedom of association. The Supreme Court, however, held the statutory rules regarding recognition and revocation of association were not violative of Article 19(1)(c), and they impose reasonable restriction on the right to form association under Articles 33 and 19(4), as the Sangh and its members come within the ambit of Article 33 and thus they stand on a different footing. It was held that the right to form association is fundamental right, but recognition of association is not a fundamental right, and Parliament can, therefore, by law impose restrictions on such right.